Britain's top court says a Brexit needs parliamentary approval before the Prime Minister can begin the process of leaving the European Union. The Supreme Court justices also ruled that the Scottish Parliament and the Welsh and Northern Ireland Assemblies don't get a say.
By a majority of 8 to 3, the Supreme Court rules that the government cannot trigger Article 50 without an Act of Parliament authorising it to do so. Put briefly, the reasons given in a judgment written by all 8 justices in the majority are as follows. Section 2 of the 1972 Act provides that whenever EU institutions make new laws, those new laws become part of UK law. The 1972 Act therefore makes EU law an independent source of UK law until Parliament decides otherwise. Therefore, when the UK withdraws from the EU treaties, a source of UK law will be cut off. Further, certain rights enjoyed by UK citizens will be changed.
Well, even though the Brexit plan doesn't need Scottish approval, the country's First Minister, Nicola Sturgeon, hailed the Supreme Court's decision and vowed to prevent a hard Brexit.
So it's now vital that Parliament gets the chance to debate and decide upon not just the triggering of Article 50, but I think the terms of the negotiating position as well. And SNP MPs will seek to work with others to stop a hard Brexit in its tracks.
Well, Gina Miller was the lead claimant in the legal fight to get Parliament to vote on when the UK can begin to leave the EU.
There is no doubt that Brexit is the most divisive issue of a generation. But this case was about the legal process, not politics. Today's decision has created legal certainty based on our democratic process and provides the legal foundations for the government to trigger Article 50.
Well, let's get some analysis now. I'm joined by Aris Georgopoulos, a professor in European and Public Law at the University of Nottingham here in the UK. Good to have you with us. So this ruling doesn't mean that Brexit won't happen, but it does mean the government has to table an Act of Parliament before it can trigger Article 50.
This is precisely the case. It's a very important constitutional judgment, clarifying a long-standing constitutional principle that the Parliament is sovereign in the United Kingdom, in the constitutional arrangements on these islands. Of course, it was a judgment about process, not about substance.
In practice, will it mean then that MPs can delay the timetable that Prime Minister Theresa May has in mind for Brexit?
There have been first reactions by some of the parties, particularly from the SNP, but also other parties like the Lib Dems and Labour, that they are planning to table amendments to the proposed bill that may delay not necessarily the timetable of the government to trigger the process, the formal process of withdrawal by the end of March, but it may delay the, if you want, the timing of the authorization that the Parliament will give to the government to do so.
Some parties have said that they want to see what the conditions of Britain's exit will be. Does that mean that they will have the chance to see what the negotiating position is before they approve it? Could they make amendments? Some MPs are talking about, well, we don't want a hard Brexit, we want a soft Brexit. I mean, how far can they dictate how Brexit will look?
This is, if you want, the most difficult part, and it is difficult, and to that extent it makes, if you want, the political, the practical implications of this judgment less, I wouldn't say less significant, but it limits its practical significance. It's the framing of Article 50 itself, which is it's parts of the European treaties, and there are two elements there that make this process very difficult. If you want, previous or prior scrutiny Parliament. And the first is that negotiations with the EU partners cannot begin before the formal triggering of Article 50. That's the first point. And the second point is that once the article is triggered, there is a very specific time frame of 2 years within which an agreement must be achieved. Without an agreement, automatically the UK will leave the EU. So it is very difficult at this stage, before there is any possibility of formal negotiations, for, in my view, to have if you want, debate about the negotiating position of the government. Of course, you could express preferences, and many MPs have started doing so, precisely that, and they are asking for a white paper. But realistically, I think it's very difficult to have a meaningful and conclusive, if you want, debates before the process begins.
Indeed. Thank you for your analysis there. Good to speak with you. Aris Georgopoulos speaking to us live from Nottingham there.